I'm the Executive Vice President for Planning for our FedSoc chapter here at Texas Law. The Federalist Society serves to provide a forum for legal experts of opposing views to interact with members of the legal profession, the judiciary, law students, and academics. Here at Texas Law, our chapter's goal is to sponsor fair, serious, and open debate. Our first speaker, Professor Josh Blackman, currently serves as the Centennial Chair of Constitutional Law at South Texas College of Law in Houston. Professor Blackman received his law degree from George Mason and clerked for Judge Kim Gibson in the Western District of Pennsylvania, and then for Danny Boggs on the Sixth Circuit. Professor Blackman has authored 3 books and over 60 law review articles, which have collectively been cited over 1,000 times. Josh regularly appears on TV and on syndicated radio programs as a national thought leader on constitutional law and the United States Supreme Court.
And I was a Texas Chair of Law and Public Policy.
That's right, and he's very active with our flagship conservative legal journal, the Texas Review of Law and Politics.
Thank you.
Our second speaker, Mr. Austin Kaplan, represents executives, employees, whistleblowers, and civil rights plaintiffs. He is the founder and managing attorney of Kaplan Law Firm, PLLC. He was the Austin Under 40 Austinite of the Year, chairperson of the City of Austin's Ethics Commission, and president of the Austin Young Lawyers Association. He is TBLS board certified in labor and employment law. Last year, he secured a multi-million-dollar jury verdict in a workplace defamation case in Travis County District Court. And since the case settled without confidentiality, you should ask him all about it after.
Ooh.
He was recently featured internationally for representing Amanda Zerowski, Kate Cox, and other brave plaintiffs in Texas reproductive rights litigation. I will now turn the floor over to Professor Blackman. Please join me in welcoming both of our speakers.
Thank you so much. It's a pleasure to be here. Also to my dear friend, we'll have a good discussion today on abortion. So let's just take a step back. I started law school in 2006. When I started law school, the idea that one day Roe would be overruled was simply not conceivable, right? We just didn't think it was possible that this would even ever happen. To just go back, Roe is 1973. About 2 decades later, in Casey, the court had the opportunity to overrule Roe. At the time, there were 8 Republican justices on the court, 8. And the one Democrat was Byron White, who dissented in Roe. Yet, through a story you all know, the court reaffirmed the core holding of Roe in the Casey case. They kind of got rid of the trimester framework, but they kept this undue burden standard. But for the most part, abortion laws would remain within the scope of judicial review. And what happened to make that happen in Casey? Justice Kennedy, O'Connor, and Souter came together with this joint opinion, and it made a few points. It said that stare decisis is such an important factor that if the court were to go back on the Roe decision, it would actually weaken the legitimacy of the court. The court also said that women's place in society is closely related to abortion, and they did not want to be in a position where they serve a retrograde women. As a result, abortion remained within the scope of the courts. And over the course of the next 2 decades, there were a series of cases where legislatures pushed and tried to get more regulations in effect. There were state and federal bans, what's called partial birth abortion. There were attempts to have parental notification laws. There were attempts to have regulations of the clinics themselves. In Texas in particular, we had a lot of those cases about the surgical standards and medical licensing. But these all sort of just nibbled around the periphery of abortion. But the issue really came to a head with Mississippi. Mississippi enacted a law that was facially unconstitutional, right? It was a law that banned abortion prior to the point of viability by any medical standard, and that clearly ran afoul of the Casey decision, right? The legislature knew this. At the time, though, it was unclear if Dobbs would ever happen. Now, for Dobbs to happen, we had to have what I call a perfect inside straight, if you want to use poker terminology. Justice Scalia died in 2016. Against all odds, Donald Trump won and filled that seat with Neil Gorsuch. A couple years later, Justice Kennedy was encouraged to step down. Again, Kennedy was the key vote in Casey and other abortion cases like Whole Woman's Health. And Justice Kennedy was replaced by Justice Kavanaugh. Yet that was not enough. In September of 2020, Justice Ruth Bader Ginsburg, the patron saint of women's rights on the court, suddenly passed away. And against all odds, Trump filled her seat in a few weeks, I'm only exaggerating slightly, with Justice Amy Coney Barrett. So now you have, for the first time since the New Deal, 6-ish conservatives on the Supreme Court. But even then, it was not assured. The Dobbs case came from the Fifth Circuit, and my good friend Judge Ho said, we have to strike down the Mississippi law because it violates Roe and Casey. But there might be some room for the court to reconsider this issue. The Dobbs case went to the Supreme Court, and if you know the certiorari process, it takes 4 votes to grant. It took almost a year to grant the Dobbs case. They kept relisting it and rescheduling it and relisting it and rescheduling it. And according to the reports, Justice Barrett apparently was the weakest link and didn't want to take the case. But eventually, Justice Kavanaugh came around and gave the 4th vote for certiorari. Even then, victory was not assured. The case was argued, was it in March of 2021? Remember, we were in the middle of the pandemic at the time. I'm sorry, March of 22. We were in the middle of the pandemic at the time. All the arguments were on Zoom, right? I'm sorry, no, but there was a lockdown and people couldn't really get to the court at the time, okay? What happened after that? There was a leak. The draft opinion in Dobbs was released to the public. Why was it leaked? Was it an attempt to lock in a majority, or was it an attempt to change the majority? We'll never know for sure. I don't think we'll ever know. Maybe we will one day. And then what else happened? There was an assassination attempt on Justice Kavanaugh's life, where a man flew from California with weapons, and he meant to kill the justice and kill himself. By the way, he pleaded guilty this week, so that will not go to a trial. All these things happened. If any one of these things went maybe slightly differently, Dobbs would not have happened. But Dobbs indeed did happen. June of 22 was perhaps the most, monumental week in Supreme Court history of my lifetime. The court decided in the span of a week, Dobbs overruling Roe and Casey, Kennedy v. Bremerton overruling the Lemon Test, and then Bruin, a strong Second Amendment decision, all in the span of a few days. I am convinced that the justices had been able to negotiate and talk more and didn't have this assassination, the leak. Those cases might come out differently, but I think they were all locked in. So we have Dobbs, this groundbreaking decision overruling Roe and Casey. What actually happened in the wake of Dobbs? Now, I'll say something that might not be popular, but it's true. The pro-life community was not ready for Dobbs. They weren't. They were caught flat-footed. I think the other side was ready for it. And I can just prove it to you with some numbers. In the wake of Dobbs, many states have had referendums. You could pass an amendment through their state referendum process. Okay? Some numbers. In 2024, 10 states voted in abortion measures. Okay? Measures protecting abortion rights passed in 7 of those 10 states. And these aren't all blue states. You have Arizona, Colorado, Maryland, Missouri, Montana, Nevada, and New York. Only 3 states they failed: Florida, Nebraska, and South Dakota. In the previous year, 4 states, California, Michigan, and Ohio. These are 2 states that swung red this past year. California, Michigan, Ohio, and Vermont passed measures approving abortion rights. So just as quickly as the Supreme Court said, let the states decide, indeed the states did decide. And most of them voted to keep some measure of abortion rights under their state constitutions. There's another way of measuring this, which is state Supreme Court decisions. Now, state Supreme Courts haven't always interpreted their constitutions fairly. Justice Brennan once said we need to look to the state courts and stuff that we can't do. Fair. But I'm going to give you some red states that reviewed these cases. The Idaho Supreme Court, Idaho, right, held that the Idaho Supreme Court does not protect the right to abortion. Okay, so that's one that goes on the right. The North Dakota Supreme Court held that the Constitution of the state has a due process clause, and the due process clause protects a right to abortion to preserve life or health. They didn't address it more broadly, so there's at least some right to abortion. Indiana held that the state constitution does not protect the right to abortion. Oklahoma found that the due process clause of the state does protect a right to a life, therefore there's some right to abortion. South Carolina flipped. They initially held that the state constitution has a privacy clause, protects abortion, and then I think the composition of the court changed, and it came out the other way. And then most recently, Florida. The Florida Supreme Court reversed an older precedent that upheld the right to abortion. So now in Florida, there's no constitutional right to an abortion. Okay. Now let me give you some numbers that might surprise you. In the run-up to Dobbs, there are all these sort of statistics saying that if you ban abortion, if you overrule Roe, there'll be such a huge decline in abortions, right? That actually hasn't petered out. These are from the New York Times. So these are not Josh statistics. These are the New York Times statistics. They say, in nearly every state that's banned abortion, the number of women receiving abortions increased after Dobbs. Increased. So in the 13 states enacted near total bans, the number of women receiving abortions increased in all but 3. I'll tell you those 3 in a minute. Some women traveled to clinics in states where abortion were legal. Others ordered abortion pills from U.S. doctors online. We'll talk about that one maybe in a few minutes as well. The only states where the number of abortions decreased, as you might imagine, Texas, which I'm sure he'll talk about in a minute, Idaho, and Oklahoma. But even in Texas, the decrease has been small. So between women traveling to obtain abortions and the mailing of various pills, the number of abortions has, if not stayed the same, it's pretty close. A lot of the sort of the predictions of what would happen have not panned out. Now, I want to walk through at a high level and turn it over in a few moments some of the big legal issues that have existed in the wake of the Dobbs decision. One is something that perhaps you didn't expect, which is discussing religious abortions. In Indiana and other states that have RFRAs, Religious Freedom Restoration Act, people said that my religion says if it's a choice between my life and having my life or giving birth, right? You must choose your own life. I said, therefore, there's actually a religious right to have an abortion in certain cases. This argument hasn't quite worked anywhere. They're still sort of figuring it out, but this is in the midst. The second major issue involves the pill I mentioned before, which is called mifepristone, and there's various other names for it. Right? These are medication that can induce abortions at several weeks after conception, and the timing of this is not important for our purposes. The Fifth Circuit issued a ruling about a year and a half ago saying that the approval of mifepristone may not be valid, and that some of the measures make it easier. For example, telemedicine wasn't valid. The Supreme Court reversed that case in a case called Alliance for Hippocratic Medicine. This was on standing grounds. They didn't talk about the merits. That issue is not dead. One of your most distinguished alum, Matt Kaczmarek, I mean that sincerely, has a case right now up in the Northern District of Texas involving states, whether states can challenge the mifepristone ban. That is ongoing. Stay tuned. A related issue is something called the Comstock Act. Who's ever heard of the Comstock Act? No one. Yeah, this guy. Right? The Comstock Act is a law passed in the 1890s. Yeah, I might be off for years. It's over 100 years old. And this is a law passed a long time ago that I'm going to summarize. It says you can't use the mails to send stuff that can induce an abortion. I'm sort of grossly summarizing it. The Biden Office of Legal Counsel said that, no, this doesn't really apply to the abortion pill. Go away. Trump, on the campaign trail, said, we are not going to use the Comstock Act to prosecute people shipping abortion pills. I don't think he's changing that. I think he's holding on that one. So I don't think Comstock's going to be an issue. But, and we'll talk about this, I'm sure, Louisiana has indicted a doctor. It was in New York, right?
Yeah, I think they've all been in New York.
Yeah. And also, I think there's a lawsuit in Texas from Ken Paxton issuing a subpoena against a doctor in New York as well. So even if the feds are not trying to police the shipment of this medicine across state lines, the Texas AG, Louisiana Attorney General, and probably some other states will get down on it to try to use process. We'll talk about the full faith and credit clause. These are actually very important parts of the Constitution about how judgments from other states are enforced. Okay. Another legal item is called EMTALA, E-M-T-A-L-A, the Emergency Medical Treatment and something Act. Can't remember the L. Right. This law basically says if you show up at a hospital, an emergency room, they have to provide you with treatment, with care. They can't just leave you on the street. So if you're a hospital and you accept federal funding, which they frankly all do, you must treat people in emergency. After Dobbs, the Biden administration had an opinion saying that a woman who has a health concern, that the pregnancy is affecting her health, needs to have an abortion to stabilize her care. Therefore, federal hospitals have to provide abortions. Okay. That was litigated in the lower courts both in Texas and in Idaho. It came to the Supreme Court, and something of a weird thing happened. The shift of the case sort of focused, the focus of the case sort of shifted to not just whether hospitals have to perform these abortions, but what if a doctor has a religious objection, right? Let's say that there's only one doctor on duty, and that one doctor on duty has an objection to an abortion. Does he have to do it? The government didn't quite answer that question cleanly, but Justice Kavanaugh pretended they did. And the court said, there is a religious carve-out. He does it all the time. It's good to be the king, right? There's a religious carve-out. And so if you're a doctor who objects, you don't have to provide the abortion. So that case kind of like pettered out, didn't really end anywhere. So now the Trump administration has sought to rescind that rule, okay? So I'm going to just pause here, maybe give some more comments after my dear friend offers his remarks. But I think that the wake of Dobbs has perhaps not been what any of us expected, right? And in many regards, it's probably gone better for the pro-choice community than the pro-life community. As a political matter, Trump wanted nothing to do with Dobbs, right? He took credit for it, but he hated it because a lot of women voted against him. 5 years from now, I don't know if abortion remains a salient political issue. I think it'll more or less settle out. I think in 5 years, maybe 10, it will not be. So the doomsday predictions from Casey from 30 years ago, I think will not come to fruition. And you know what? Maybe Dobbs will make federalism great again. Thank you.
Okay, great. Well, thank you, Professor Blackman. We agree on some stuff, which is always fun.
That's good.
Yeah. and thank you all. It's nice to be here with y'all, with the students, with the future leaders of Texas, and here with my fellow reproductive justice advocates. I got a few.
Hi there.
Big thank you to James, Jordan, and Chris. If we can have these hard conversations out in the open and better understand the strengths and the weaknesses of our positions, then we are not truly debating and we are not truly learning, right? So, thank you to the UT Law Federalist Society, who has a long-standing and unbroken tradition of discussion and debate open to the entire UT Law community and the public at large. Proud to know that we share this commitment to open access to information, a cornerstone of our free society and public institutions like the great University of Texas. Given that rich and inviolable tradition in this forum, I simply could not say no. So, I understand Professor Steve Vladeck used to occupy this seat. He is a noted constitutional scholar, Yale law grad, distinguished law professor, extremely funny, and now you've got me.
And very tall.
That's the only thing we share in common. I'm a former karaoke host. I'm a current recreational pickleball player, and there's a pickleball tournament today, it turns out, which I haven't been invited to because I'm pretty good. You don't want me there. I attended the University of Illinois College of Law, which is conveniently located next to what we assume was an experimental cow manure pasture, and so congratulations on your speaker upgrade. I am not a constitutional scholar, although I do intermittently play one on TV once in a while with Professor Blackman on the other side. I'm not a law professor. What I do is I'm a practitioner. I do employment law, I do whistleblower law, I do civil rights for people. So I deal all day, every day with real clients, real people facing real issues, and I think that's why I'm here. I did represent Amanda Zarowski in her path-breaking case, and Kate Cox in her case, which obviously many of you saw, garnered eyeballs statistically from, I think, every human being on Earth that could see. And so, it was an honor and one of my proudest moments to be a part of those cases. I'm a strong believer in what we did in those cases. I'm interested. I'm interested in the politics of that. Like, we're talking law, but I'm interested in the politics of this. I'm interested in the theory of this. I think that I'm in a room of people that believe in limited government, but I don't know what that means. I don't know what the principles of limited government are. Are we limiting House members who are new mothers from voting by proxy? Is that limited government? Are we limiting speech, saying things like DEI on college campuses? Can I do that? Is it a violation?
There'll be a case coming in a minute.
I was going to say, I don't want to be deported unless it's
Do you have a
like
security clearance or no?
Costa Rica or somewhere really nice. Is it limited government to give the unitary executive give the executive unitary power, unchecked powers of extraordinary rendition. What about foreign competition? Can we give the executive unlimited powers to king-like powers to institute undue tariffs on a whim, throw markets into a tizzy? Anyway, I'm interested in these issues and how they apply generally, and I'm interested in how they apply as well to the issue of reproductive rights, because it seems to me that, it's a highly personal decision that you make with your doctor, and to the extent that you cannot make that decision, the state is involved in the decision. So it's not a limited government action, is it? It's government getting involved in your personal business, getting involved in your bedroom, getting involved in your sex life, getting involved in your reproductive life. And so to the extent that we're listening to each other across the aisle here or across boundaries, I just want to plant that seed of something to think about. And to my colleague's point, and I think it's an excellent point, I don't know that what we on the reproductive freedom side call the antis. I don't know that the people on the pro-life side were ready for the reality of what it means to institute an entire abortion ban. No abortion whatsoever. That's it. See you later. Not possible. We've not thought about the practicality of that, and so the cases that we face with these real people, like Amanda and like Kate and like all the rest of our plaintiffs, they weren't. They're not sitting here, they're not law students. They weren't sitting here thinking about these things. They were people that got pregnant and dealt with these major issues. They got pregnant in Texas. The pregnancies were not working. They were wanted pregnancies. They were not working out. There were major health problems, and they could not get treatment from their doctors, right? And so they went through horrific experiences and then called the attorneys to be like, what is happening here? And we said, this is happening by design, because there was no plan. Get rid of abortion entirely. Okay, what happens if an 11-year-old gets raped by her uncle and is pregnant? You guys tell me, right? Because right now, what happens in Texas when that occurs? Are we cool with that? I just want to be real with y'all. I know we're talking policy and stuff, but let me make you uncomfortable. Are we good with that? Because the legislature right now is in session and is working on fixed bills for the life of the mother. Those have absolutely no exceptions for rape, for incest. Sorry, I don't mean to make you uncomfortable with the Chick-fil-A, it's sitting poorly here. But it's real. These things happen. Maybe they don't happen that frequently, but they are happening. And it seems to me in a modern society, we should have some way to do this. And as I thought about personally, I'm not speaking on behalf of any organizations, just me personally, as I thought about, how this works, I came back to that concept of viability that justices struggled with in the 70s. How do we figure this issue out? Because at the end of the day, right, the mother has some rights. And we could talk about where they come from and where in the 14th Amendment, which particular. Let's set that aside for a minute. The mother has rights, right? We live in a modern society, in a modern world, and a mother has rights. And at some point, that baby has rights, and we all agree with that too. Once the baby is born, that baby is a human, that baby has vested rights. But we're struggling with what are we gonna do in the interim period during the pregnancy, right? And the court sort of dreamed up this viability standard, and my gosh, looking back, it makes some sense. Because before the baby is viable, before the baby can survive on its own, it requires the mother. And so if you have to pick whose rights win in a trolley situation contest, you must pick the mother. You must. Because if you don't, the baby's not gonna survive either. That makes no sense, right? If the baby is viable and the baby can survive, it makes sense to vest it with some rights. Because now, that can be a human as well. And now we need to do some balancing. So as I look back to what happened in the history of this issue, I think they sort of did figure it out. Now we've undone that, right? And now what do we do? Because now the mother in many situations has no rights. And a baby who's not viable has more rights than the mother. So now we're gonna make decisions that you might agree, some of you might agree, don't say it publicly because I don't want to ruin your career for Texas Supreme Court Justice, but insane. This is insane. It makes no sense. Why would we harm mothers who want these pregnancies, who want to get an abortion so that they can become pregnant again, just cause? It doesn't make any sense. So when these cases, the Zarowski case, the Cox case, were presented to us, we thought, I thought naively that everyone would agree. This is messed up and this is wrong and we got to do something about it. But what got lost in the ether since then is what happened to Kate Cox was her doctor said, you have a pregnancy that is not going to make it. I'm sorry. You got 2 kids already. Your pregnancy that you have now with this baby you want, it's not going to work out. It happens. I'm sorry. It just happens. It's sad but true. The medical recommendation here is you terminate this pregnancy and go try again, right? Have another happy, healthy baby. We're going to bring more babies into the world. My job in that case is to bring another baby into the world, right? But I'm an abortionist here because that's what needs to happen in order for that baby to exist. Because if you don't get the procedure, you're going to do harm to the mother potentially. You know, you're not going to have a successful pregnancy no matter what. So it doesn't make any logical sense, right, to go through that. So we took it all the way to the Texas Supreme Court. Apparently we were the first case since Roe, since the 70s, in any of our lifetimes to go seek court intervention during a pregnancy to get a procedure done. And the Supreme Court said, sorry, not this time. Go talk to Texas Medical Board, go talk to the legislature. But here's the funny thing, as we sit here during session, the legislature is doing nothing to solve that problem. All the bills that are proposed have no exception for what Kate Cox went through. So what are we doing? I think there was no plan. Let's get rid of abortion. Okay, but now what? Well, I don't know. It'll work itself out or whatever. And so, you know, people in that situation now are fleeing the state and are using, you know, pills to solve this problem on their own. But that's not a great solution to this problem, right? I think we do need to wrestle with this. And so I'm encouraging all of y'all, including, and especially those that are staunch, you know, pro-life, no abortion under any circumstances advocates to wrestle with this issue. What would you say to these people? What happens? I can say this, other people can't. What happens if this happens to you and your family? What would you expect? You would be like, well, I know what I'm going to go somewhere else. Well, hold on. You know, you have that privilege, you have that right, you have the ability to buy plane tickets, you have a passport, whatever. Not everybody has that ability, right? And what if you get what you seek and it really is shut down in this terrible situation, which did happen to my real clients who are real people with real families, happens to you? You know, think about it deeply, because I think, you know, I sort of share that naive belief still that like we can all agree that, you know, something needs to happen here for reproductive justice and reproductive freedom for people. You've got to make sure that women have their fundamental rights, and you've got to wrestle with that. You have to define it. You can't just take it away. It's not going to work, right? And I think that going back to policy and public opinion, the public opinion vets this out too. Like public opinion, you know, whenever it's polled, and I've seen it, is strongly in favor of exceptions for rape and incest and fatal fetal anomaly, all these things. This just doesn't make sense otherwise, but that's not what the Texas legislature is doing. And, you know, we'll see how it plays out. So a brief, and I lost track of my time, let me share. Oh, okay, a brief look at Dobbs. So my Professor Blackman talked very well about stare decisis and the opinion, and he delved into the politics of it, and I think that's right, but he left out one fun fact, which is true, that of course, Merrick Garland was nominated for the open seat on the Supreme Court. Mitch McConnell, Republican senator, of course, refused to hold confirmation hearings because it was too close to the election. Then lo and behold, as if by magic, the exact same, or almost exactly the same factual scenario occurs again just a few years later when Ruth Bader Ginsburg passes away, and the hearings are held immediately, and the justice is confirmed, bringing forth this decision, right? And so, you know, now we're dealing with the exceptions, we're dealing with the use of the mails, we're dealing with like freedom of travel and privileges and immunities. It's raising these really wild issues, right? As people are like, well, we'll work around this. You know, I don't know how long this kind of situation continues in this sort of workaround thing. But a little bit on Dobbs. Undoubtedly, of course, Dobbs, the greatest legal opinion of all time, I'm sure we can all agree, undid nearly 50 years of stare decisis, including multiple Supreme Court decisions itself that created a robust doctrine. Decisions as recent as 2016 that the Supreme Court read the 14th Amendment and said that this right exists in the 14th Amendment. Then, of course, for mystical, unknowable reasons, it read the same unchanged text in 2022, came to the exact opposite result. And it can't be because society changed or anything to do with outside forces, because, of course, that would be anti-textualist, and we don't do that here. So I assume that it was just that those prior justices did not know how to read good like me. So, but the reversal is good because we don't want the high court to get complacent or too reliable or predictable. That would cause future parties to become very bored and would create less work for lawyers. So remember that. The other thing about it is that Brown versus Board, of course, was a similar reversal where the court revisited opinion that was wrong. And of course, Dobbs will be the Brown versus Board of our Andrew Tate times. Roe and Casey inflamed politics, and I'm here to tell you that Dobbs calmed everything, and now there are no more disputes about this issue, so that was great. And viability, of course, is criticized as policymaking, so the court substituted a policy where the rights of the unborn fetus, as I just discussed, outweigh the mother force that the state is forcing to carry the fetus. So now we have a preference to protect fetal life that will always be a rational basis to support any law. In other words, states do what you will. Unfortunately, that will outweigh the protection of the health of the mother when those conflict. So TBD on those. Question, whether you took the exact same pre-Roe 1925 Texas law that criminalized the mother for the abortion right back to the Supreme Court, would they strike that part of it that criminalizes the mother? Probably not, right? For rational basis, but you do have to wonder, like, where is the line drawn now? And the court didn't really do very much for us in Dobbs. So it did say that women are not a discrete and insular minority, so take from that what you will. It really does not do, obviously, a great job of facing up to the practical impact on women, and that's where my practice is. Like the real deal stuff that's happening, in the course of a pregnancy, which is, unfortunately but true, has always been dangerous and still is a dangerous thing. Complications occur. I mean, it just is what it is, right? It also, by the way, and this has been an interesting talking point for Texas, it doesn't do much, right, to vindicate the rights of physicians to do what they have to do, administer medical treatment according to their professional judgment. This was one of the issues we raised in our cases in Texas. Like, look, if you don't want to go with the rights of women, where we think you should be to begin with, what about the rights of wealthy physicians? Don't they have rights in Texas too? Like, they want to practice, they don't want liability, they obviously don't want to go to jail. Can't we clarify it for them? So to the extent the ball is moving in the legislature this session, I think that is helping carry the day in the politics of it. But I do wonder, you all are intellectually curious law students and people. And so, for those that think that Dobbs is the best thing since sliced bread, the court explained the problem from Roe that it fixed in Dobbs, right? Even though the Constitution makes no mention of abortion, the court held that it confers a broad right to obtain one. That's wrong. Okay, you can read the text of the 14th Amendment from 1868 and agree with that technical statement. But hold on. What about Loving versus Virginia? 1967, Supreme Court states you cannot ban interracial marriage. Justice Thomas and Dobbs called that decision fundamentally erroneous. He said, bring it back, and I'm going to ban interracial marriage in this country, or at least allow states to do it. Who thinks that's a great idea right now? Only me? Y'all call yourself textualists. The 14th Amendment doesn't say anything like you have a right to interracial marry in this country. Come on. Thought I was in the ACS for a second here. This is the problem with Dobbs, right? That's Loving. That one's maybe the most outrageous one to consider. But that is true about Justice Thomas, and if it's not, Professor Blackman's going to correct the record for sure. Griswold versus Connecticut, 1965, right to contraception, same thing, not written in the text. Do we want to overturn this? Do we want the feds out? Oh, I've got one, all right. I think Obergefell might be one of the bigger ones, right? 2015, it said we find a right in the 14th Amendment in the Constitution to gay marriage. Thomas says the same thing, like, it's not in the text, we got to get rid of it. What would you say if that were overturned to all the happily married same-sex couples in Texas and throughout the country, right? All the good that's come since that decision. I think it's fair to say, like, if that were to get overturned, Texas would go right back to banning gay marriages the way it was. And I know that because when I first started this law firm in this practice, 2015 in June, that case came out. The Attorney General sent a note to county clerks across the state implying that they, for religious reasons, could refuse to issue same-sex marriages even though the Supreme Court said you must. We ultimately brought a case in litigation and resolved the case, ultimately the clerk's office issued our client their license to get married, just like the Supreme Court said. But hey, I mean, I don't know that Texas's position has changed on this issue, right? So, it's an interesting question. Like, what is the Pandora's box of Dobbs? Where does this go next? And what does that mean? And just think about it, in terms of the law and in terms of a country. How do you have a country where you have a right to, have an abortion if you are a victim of rape or incest, or you have a fatal fetal anomaly in New York, right? But that's a crime punishable by life in prison in Texas. So it's the same action, but neighboring states, Texas and New Mexico, for example, you do the same thing. Here you go to jail forever, and there you actually have a right to do it. How do you run a country that way, right? Anyway, that's what I got.
All right, sorry, I made a gun. I was like,
anyway, yeah, guns.
Gun,
Yeah. I mean,
yeah. Anyway, okay. So the title, God bless Texas. The title of this event is "Who Decides," and I am so grateful we're having this debate. Do you know why we're having this debate? Because of Dobbs. 5 years ago, who decided this question? Anthony Kennedy. One man. Not a very wise man in my view. He's not. One man got to decide who has a gun, who doesn't. Right? Who gets a death penalty, who doesn't. Who can have an abortion, who doesn't. One man. Is that any way to run a country? No. I would much rather the distinguished people in the Capitol, or is it that way? I don't know where I am, right? In the Capitol, a few blocks away from us, make these decisions because they are politically accountable. And if they refuse to pass bills that address the fetal anomaly point that my friend mentioned, that's on them. And federalism means something. You can vote with your feet. I lived in New York as a kid. I'm never going back there. The gun laws are terrible. I will be a felon there if I brought my living room to New York City. I'd be in jail for the rest of my life. If you don't like the laws here, God bless, right? I mean that. People have a right to be where they want to be. And if you have a legislature that has a choice of what laws to pass, there's political accountability. State elections matter. We have races for governors, races for attorney general that aren't super close, but close enough. Okay. So again, I am happy to have this debate. I'm happy to decide this. I think I try to agree with Mr. Kaplan on a lot of the merits on which laws should be passed. I think some of the examples he mentioned are particularly egregious, right? But that's a debate we can have now. In the past, we've had to, talk to a federal judge in Austin. A couple of them seem to get all the abortion cases one after the other, right? They would decide this, and not people in Austin's capital. I'll just mention the idea of Obergefell and Griswold and Loving. I think as law students we're taught, and it's a myth, that we have to look at the Supreme Court to remedy all social ills, right? Let me tell you something. When Griswold was decided, did you know this? Connecticut was repealing the birth control law. Did you know this? By the time Griswold was decided, Connecticut was repealing their law. The case was arguably moot, but they decided anyway. We don't need to look to the court for salvation, right? In Obergefell, right? By the time Obergefell happened, gay marriage was not quite a nationwide 50-50 issue. I think today it's over 50% nationwide. I don't know, to be completely honest, that Texas goes ahead and bans gay marriage. I mean, it's probably true they'll give carve-outs to the clerks to issue the licenses, but I think they wouldn't change that. As for Loving, my goodness, by the time Loving was decided, interracial marriage was accepted almost everywhere. In fact, the reason why Loving happened was he went back to Virginia and saw this weird habeas challenge to an old conviction. We don't need the Supreme Court to save us. If Dobbs does something else, it will prove to us that we can govern ourselves. Judge Sutton wrote a book called Who Decides? We can decide. We don't need Anthony Kennedy to decide. Thank you.
Just want to take some questions?
I'd love to take questions.
Sure. Oh, got a lot.
Please be concise and actually finish your sentence with a question mark.
Austin, you mentioned considering exceptions for rape, incest, and fatal fetal anomaly, and I want to focus on that. How would you respond to concerns that tests for such anomalies are not always 100% correct or accurate, and that allowing abortions based on pain of disability diagnosis promotes discrimination on individuals with disabilities, particularly given the high amount of abortion rates for conditions like Down syndrome?
Yeah, great question. So I get a lot. I get hate mail and love mail. I'm sure you do too.
Oh, lots of it.
If you take a strong position on a polarizing issue, that's just where it'll be. And so one piece of contact info I got, and it was almost interestingly, let me answer this with a parable, with a fable. Kate Cox is a real person. She's a real client. She really lives in Texas. She really has a family. She had a third child after we got her out of state. She had her abortion. She came back. She got pregnant. She had a third child. God bless her and her family. So, to the extent that I take criticism for being some kind of anti-baby crusader, I created +1 babies. So that's nice.
Mazel tov.
Thank you. Yeah, and I'm a big fan of that, right? But I did get some heat, and I forget from where, that said, like, listen, the diagnosis was, oh gosh, I'm forgetting off the top of my head. It wasn't anencephaly, it was the other one. It was trisomy 13. And somebody said, like, look, there's one person that we can identify in like the whole United States, I believe it was, that like had something similar to trisomy 13 and survived. So like, what if you're wrong? What if doctor's wrong? And I'm like, look, I'm not a doctor, right? Like, and I don't play one on TV. Like, my position on this is pretty simple. I think that it should be a decision between the doctor and the patient, and I think it should be informed by medicine. And I think the state should be out of the decision in a perfect world, right? But in that situation, the doctor had told her, and I think she had 2 opinions, that the child was just simply not going to survive. It just wasn't going to happen given the condition of this particular child. And I think it probably does depend on the diagnosis, right? But you could kind of like play the hypothetical out and be like, well, you're 2 professional basketball players and you've got a pregnancy, and like the doctor says your kid's only going to be like 5'8", like Austin over here. What do you like, you're going to try again and see if you get like a 7-footer, like, okay, that's gross. We don't like that, right? That's making us all really uncomfortable. These are kind of like future issues in medicine, right? But yeah, I think that, it was relatively clear cut in those cases, and to the extent that it creates these problems, the way that I would handle it, of course, would be let medicine decide, right? Because one of the challenges we're running into in trying to like hash it out and write these bills, and not me, I'm not writing the bills, but the legislators and the medical associations and everything, is you're trying to like lawyer and legislator in a operating room. Like, that's really hard to do, because like every patient's complicated, and like med school takes longer than law school, allegedly. Yeah. So there's a lot they have to know. But I think that there is a comfortable space that is respectful, obviously, of people with disabilities, and also the rights of women to like choose what they want, and their doctors, I should say, to choose what's going to happen with respect to their health, with respect to their bodies, with respect to their pregnancies. But yeah, I mean, we don't tussle with that in Texas because we have a full ban, but you'd be tussling with that on the other side if you had a full non-ban, if you had a full right to abortion at any time throughout the pregnancy and there was no limitation on it. I think that you would be running into those issues much more frequently. So,
yeah. So
you may see them in other countries where there's different rules.
So let me just table one small constitutional issue. The Equal Protection Clause, right? You all learn about equal protection means you can't treat people differently based on race or gender, but that's not the original meaning. Protection means protection from violence. And the Equal Protection Clause does not apply to people who are born, it applies to persons. So they dodged the issue in Dobbs of fetal personhood. Does the state have an affirmative duty to protect the unborn who might have a disability? In other words, the mother is the bad guy in this case. They dodge that issue. I'll just wait. One other point, which he'll get mad at me. A lot of these doctors are very much in favor of abortion. Can it be said that maybe they might exaggerate some of the risks that might attend? This, I know he's been mad at me. This came up in Whole Women's Health about the risk of having these accreditation standards, of how much would actually happen. Okay, I know you can be mad at me at that one.
No, I'll bite. So
Yeah.
The doctors on either side of these issues
Yes.
at the Supreme Court I'm not saying it's not a fact, they tend to be regular actors in this space,
Yeah.
right? I mean, that just is what it is. So for example, in the mifepristone case, I took a look at it. I was not involved in that case directly, but we heard from Dr. Skop, who lo and behold was the expert witness for the state of Texas in Zarowski, and also spoke to the Texas Medical Board. I mean, this is a person who has strong beliefs on the anti-abortion side. I'm not saying anything that's not true here. And it was the same thing for the other doctor, I believe, that was the expert witness in the case, Dr. Harrison. So yeah, I mean, you're going to have doctors that are advocates as well, but I think it's probably not true to say that most doctors are advocates one way or the other. I think it is true to say that like the standard of care for the American Medical Association for OBGYNs who deal with this all day long suggests a lot more discretion in making this decision and providing this treatment than the state of Texas would ever, as a political issue would ever allow, given where we are today. I obviously personally would side with the doctors, and I think again it's because of the personhood. I think it's because of the maternal health issue. I think it's because of control over bodies, and I think if the doctors say generally we want to be, in this space, I'm okay with it. And again, it goes back to the original issue. When you think about the rights issue, I want y'all to struggle as much as I do with the issue of viability and what the court said in the 70s and where they sort of dreamed this up. Like the rights. Do the rights really vest to this point? Fetal personhood, or like what is it? As soon as conception, like personhood at conception. Do the rights to being a person really vest at conception? Like, just think about that for a second. Are we like? Does that make logical sense to us? It can't exist. It's not a person. It can't exist on its own. It can't make choice. It's not out there. Like at what point do we want to, at what point as a legal system should we be vesting these rights? At what point does that make sense?
One more question.
Yeah, I saw a hand up somewhere. Yeah, right there.
So, Professor Blackman, you talked a little bit about how in 5 to 10 years you thought this issue would kind of dissipate as a political issue. And my question is genuinely like, what makes you think that? Because part of the Dobbs logic seemed to be to me that the Casey logic was wrong, that this issue as a political issue is here to stay. And that, to your point, it should be up to the courts to decide. So I guess my question is, what makes you think it's really going away?
Well, I look at the state referendum, and even in states that voted for Donald Trump, like Michigan and Ohio, they voted for rights to abortion on the state ballot. In Texas, it's actually very hard to get something on the ballot. I don't think it's going to happen, at least in the near term. But in state after state, public opinion polling shows at least some limited right to abortion. So even if the people think that Casey was wrong for adopting the viability standards as a matter of con law, they may still adopt that as a matter of public policy. And that's a choice I think that'll happen. Again, is it 5 years or 10 years? I don't have a crystal ball. But I think even between now, 2025, and 2022, the issue is much quieter. I mean, he represents some clients, I think, some very tragic cases. Thankfully, those have not been many. I mean, you can count them, on maybe a couple hands. But for the most part, the issue of ectopic pregnancy, that was a big issue at the beginning. I think that's been settled. Like that's clean, maybe.
It's in the bill now.
Right. So in other words, a lot of these issues will get sorted out. Anytime you have a legal regime that's overruled, it will have some waves, some ripples, and eventually, I think it will sort of quiet down. Where this goes, I couldn't tell you, but I think again, if I come here in 10 years, we'll all be lawyers making $1 million a year, and I'll also be a law professor, right? You'll say, "Oh, yeah, Josh, you were right," or "Josh, you're an idiot, you were wrong." But I think this will sort of quiet down.
Yeah, and I'll still be doing these cases pro bono driving a Prius. But the important thing is that, and to an important distinction, political accountability, but I think weigh that, if you would, against fundamental rights, right? So who decides is a great question, is an interesting question and one to tussle with. But what about for fundamental rights, the right to your personhood, the right to do what you will do with your body, right? These kind of really tough and personal decisions. And I'd be remiss if I wouldn't point out that obviously we're two men talking about this issue, and this issue really affects women. It affects women's bodies. It affects pregnant women. And my clients are here in town still speaking out about these issues in public forums to let people know what they went through personally. And then, on the issue of who decides, here's where we're at in Texas today. We've got 3 bills pending on this issue at last I checked. SB 31, HB 44, the Life of the Mother Act. That one's pitched as a negotiated bipartisan agreement. It does put ectopic pregnancy into the exclusion list as opposed to affirmative defense, which arguably is good. But again, no exception. I mean, here's where the fundamental rights don't match up well with the political action, right? Because we know the polling says that there's tons of support. There's overwhelming support for exceptions for rape, incest, and for children who become pregnant, by God, right? But the politicians are not doing it. There is no exception in the bill. There's no exception for what happens before you become septic, which is what happened to Amanda. There have been multiple deaths reported from sepsis, 2 of them, Gisele Barnica and Nevaeh Crane. So I wanted to mention that. There's no exception for fatal fetal anomaly, which is exactly what happened to Kate Cox. It's just not in the bill. So the politicians are not wrestling with these issues right now. It keeps the confusing prior definition. It keeps the objective standard for doctors, not subjective, meaning that if you're a doctor, you make a ton of money, you think you're doing the right thing, and then Dr. Scott looks at your file afterwards and disagrees, you could find yourself in jail. That's a scary place to be if you're a doctor. Doctors are not, most doctors are not advocates of this space, right? And they just want to do their thing and get to the golf course, right? So you've got to make it so that they can do their thing there. And then, of course, there's an interesting issue. We won't have time to get to the reanimate the repeal by implication or not 1857 pre-Roe law that criminalizes the mother. Here's the thing. The politicians know, apparently the most unpopular thing of all seems to be criminalizing the mother for the abortion. And so, anytime that comes up, people are running screaming from that, but that is what the Texas law said. That was why it went up to the Supreme Court in the 70s and was struck anyways. So, and an interesting history, for those of you who don't know it, that case, Roe v. Wade, is really kind of born here at the University of Texas Law School. It was Professor Sarah Weddington who brought the case as a younger-than-us attorney to the Supreme Court, was, I believe, her first argument, and was a surprising win. So the history of it really is right here in these halls. The other two laws are SB 33 and SB 2880. SB 33 would prohibit cities and counties from paying for, interestingly, not abortions, but like childcare or counseling for folks who would leave the state to get abortions. So, you could see the dragnet is expanding, right? And that should be concerning because it's going to infringe on other fundamental rights like speech, travel, etc. But let me scare you even more. SB 2880, Women and Child Protection Act. That's the pill bill. The state took SB 8, which you may have heard, that's the abortion bounty hunter bill, which created kind of like a zombie Frankenstein key tam mechanism to go after it was called the Heartbeat Act. So to go after abortions while abortion was constitutionally protected activity. This is wild constitutional stuff that someone should write a book about, but I don't really write books, so maybe it'll be you. But in any event, it was constitutionally protected activity. A state passed a law that basically outlawed it, and the Supreme Court took a pass on the injunction, which allowed it to continue. So, bad behavior not punished is rewarded. The Texas legislature now has a bill that may pass that will make it essentially a key tam for private citizen suits, minimum of $100,000 statutory penalty against app providers, against ISPs, against anybody basically that does anything to do with providing, mifepristone, the abortion pills, even if they're provided through FDA-approved telemedicine appointments to people in Texas. So it has everything. It has one-way fee-shifting liability. It has what I call a crazy town provision that says if you counterclaim a case like that, you basically have to pay the other party, you lose, and you pay them $100,000 nearly guaranteed. Who's ever heard of that? Joint and several liability for the attorneys involved in the case, 3 years to file a separate lawsuit against the attorneys, so you shall not challenge this law. And my favorite, and y'all check it out, see if I'm telling you the truth, it robs judges of the ability to review the law and gives judges, this is awesome, personal liability at the end of the section 171A.407. Never seen anything like this before. Stop me if you have. If you, judge, issue an opinion that says this law sucks and it's unconstitutional, we're going to sue you personally, take all your money, and thanks for playing. Who has ever heard of anything like that? But that is where we are today, post-Dobbs, with the let's figure out a plan to eradicate this activity from the face of the earth. I would leave you with this. If you think any of that is a great idea because you're so driven by this one issue, I'm here to tell you that swap out the word abortion for the word assault rifles, see you in 4 years, and you're gonna have a system that does not work. You can't have states outlaw constitutionally protected activities, because then all the constitutionally protected activities will fall eventually. They haven't yet. Don't ask me why, but they will. So,
All right, I'll let him have the last word. Thank you so much.
Thank you.
Thank you. We're out of time.